Again, for those that have just joined, thank you very much for joining. My name is Andrew McCallum. I'm the Manager of Membership and Community Engagement at auDA, and really pleased to welcome you to this webinar today, Trademarks, Business Names and Domain Names. Really going to get into topics around exploring trademark searches, applying for an Australian trademark, and how domain names and trademarks serve as valuable assets for brand recognition and consumer trust. Before we start, I do want to acknowledge and pay my respects to elders past and present, to those that have passed before us, and to the members of the Aboriginal and Torres Strait Islander community who are attending here today. I want to specifically acknowledge and pay my respects to the Wurundjeri people of the Kulin Nation, who are the traditional custodians of the land in which I'm coming to you. Before I introduce today's guests, I will mention this webinar is being recorded and will run for 45 minutes. Without further delay, I'm really delighted to introduce our special guest, Sergey Litvinov. Sergey is a project officer at IP Australia, and as a qualified trademarks attorney, Sergey has designed many updates to the Trademarks Office Manual of Practice and Procedure, including better guidance on assessing the relevance of business names in trademarks evidence. Most importantly, Sergey has been kind enough to share his expertise with us today. We will have time for questions at the end of the presentation, so if you do have any questions, anything you want to get clarified, please do add them to the chat, and we'll do our very best to get to them, or very best to fire them Sergey's way, I should say, before we wrap up. On that note, Sergey, thank you for joining us, and I'll pass over to you.
Great. Thank you, Andrew. Just waiting for the slides to come up. Yes, hello everyone. I am here in sunny Canberra. Los Angeles absolutely wishes. Thank you all for joining today, and thank you, auDA, for having me. It's a pleasure being here. As Andrew introduced me, my name is Sergey. I am a project officer working in the quality and practice area of the Trademarks Office at IP Australia. Today we'll be going over all things trademarks and their relationships with business names, registrations, and domain names. All of these are important threads of a brand tapestry, so knowing the differences should prove quite useful in your day-to-day trade. I'd love to kick off, but unfortunately I'm not quite seeing the slides. It's a black screen at the moment.
They're certainly showing to the audience, Sergey. So we've got what is intellectual property up there.
And
slide 2.
And Andrew, can't quite hear you. Oh gosh.
Can you hear me now, Sergey?
Technical difficulties right out the gate. That's great.
All right, let me just chat to you briefly.
Oh, good, Andrew, excellent.
And Lauren, if I can just get you to reload those slides, please, for our audience. And there we go. You got that, Sergey?
Yes, stunning. Oh, look at that.
We're away.
Luckily, I deal with trademarks and not patents, which are more technology side of things, so it really shows. Thank you. Thank you for your patience. All right, so let's just pull back. First, a little bit more about IP Australia. We are the government agency that administers registrable intellectual property rights, including patents, trademarks, design rights, and planned breeders' rights. And that's just the slide we were just on, Lauren. Thank you. Intellectual property refers to creation of the mind. Anytime you create something new or original, you're creating IP, whether it's brand of the coffee you drink, the chair you sit on, the shoes you wear, IP is everywhere. It's a little different to other types of property we often think about. So physical, tangible things like buildings or cars. Instead, as the name suggests, IP is intangible. Your business may have a wealth of IP, from the name on your door, side of a truck, to an innovative new process. There will be things that differentiate you from your competitors. As your business grows, so too will the importance of your intangible assets. Australian IP laws provide a legal framework to protect your creative ideas through IP rights. So today we'll be mainly focusing on trademarks, but I'll quickly explain some of the other IP rights that exist in Australia as well. So these are the 7 types of IP. On the left, we have the registered IP rights, which are administered by IP Australia. And on the right, we have the strictly unregistered IP rights. As the name suggests, these exist without you needing to register them. Each of the IP rights protect different things. If you use an example of how IP may relate to a coffee shop, for your trademark, you will have your brand name and a logo. Trademarks are, in essence, signs indicating trade origin, and in more precise terms, a trademark distinguishes your goods or services from those of other traders. We have patents, being the way a new invention works, or the invention itself. It could be the way a coffee machine works that is new and innovative. I personally was always impressed with the patents regime because you often have to have an entire science degree as well as being able to be legally savvy to work in that field. I personally can barely stay in my own lane. Then we have design rights. These aim to protect the visual appearance of a product. So that might be the way your coffee pod, coffee cup might look like. Back when I was at uni, my favorite tutor described design rights as being perfect for superficial people, which is probably why it makes sense why I like them. I always thought that was funny. Then plant breeders' rights. So that might be a type of coffee bean. PBRs, short for plant breeders' rights, they protect new plant varieties, and these are very, really important for our farmers. For then registered rights, you have copyright, trade secrets, and circuit layouts. We are all familiar, of course, with copyright, which protects various creative endeavors put into material form. Trade secrets, the famous example here is the Coca-Cola recipe, and circuit layouts as well. These can be protected too. These are not registered as they are protected automatically, so upon their creation. And to reiterate again, IP Australia is not involved with unregistered rights, but we do have more information on our website if you're interested about that side of intellectual property law. People often want to know which right is best for them, but every business is unique. Your best strategy may use different types of these IP rights in combination. They can complement each other to protect different aspects of your business. And it's important to consider an overall IP approach early when establishing your idea into the market. Next slide, please. So yes, we handle the registrations of patents, trademarks, designs, and PBRs. Registered IP rights are quite strong. They give you the exclusive right to determine who can use your IP and how it can be used. They give you the opportunity to sell, license, promote, develop your product while limiting competition from others. And having a registered IP right reduces the chance of your idea being replicated as well and gives you a recourse to take action against copycats. The classic and, I'll admit, embarrassing turn of phrase that we always say at IP Australia is a trademark is both a sword and a shield. And it goes for other IP rights as well. And registered rights can also be sold for financial gains and can be extremely valuable in opening up new opportunities. For example, IP rights can be used as a bargaining tool for a startup looking for investors or licensing a product to be made overseas, so that you can establish the brand's market share. IP can be incredibly valuable. Next slide, please. Next slide. Jeez. You might have picked up on this already, but something that is not a type of intellectual property is a business name registration. A business name is an administrative instrument. It is a name or title under which a person or entity conducts a business. If your business does not operate under its own entity name, like for example, GLM Proprietary Limited, or your actual name as a sole trader, you will need a registered business name. To register a business name, you will need to have an ABN or be in the process of getting one. So let's go a bit more into the process of how to register the business name. You do have to register it with the Australian government so that you can operate as a business. The key operative word here is that it's a legal requirement. There are a few different ways you can register a business name through the Australian Government Business Registration Service, ASIC, or through a private provider. You can also use these avenues to register an Australian company or ACN. An ACN is used in relation to an entity when it registers as a company under corporations law. So we are proprietary limiteds of the world. Next slide, please. And this handy table over here from Business Queensland helps outline the differences between a business name and a registered trademark. The critical thing here about registering a business name is that it does not provide exclusive ownership of your business name. As I said, it is a legal administrative requirement. You can use a registered business name to identify your brand, which is where sometimes confusion between a business name registration and a trademark registration comes from. Because of course, my business name is Apple, but my trademark is also Apple. So there's like a blurring of the lines. However, to reiterate, a business name doesn't prevent other people from being able to register and use similar names like trademark rights do. They're entirely different schemes. So to gain assured exclusivity of a particular business name, you need to register it as a trademark with IP Australia. Next slide, please. Trademark, they are your brand identity. It helps customers differentiate your products or services from those of your competitors. So let's try to delve deeper into trademarks to get a better sense of why in the world would you want to get one registered. All right, this is my favorite part about talking about trademarks. And that's saying a lot because I can easily be caught running my mouth about the subject for hours on end. These are a few examples of different types of trademarks. We know that trademarks can be a logo, a slogan, a phrase, a word. But the legal definition of a trademark is a sign. So anything that can fit that broad definition can potentially be registrable as a trademark. So here we go. We have here included letters, colors, your Cadbury purples of the world, smells, pictures, movements, aspects of packaging, and any combination of these. My personal favorite for smells are quite rare as a sign, but it is the smell of grass on a golf tee. That's quite fun. Oh no, I'm lying to you. It's the smell of eucalyptus on a golf tee. So next time you are caught smelling your golf tee, you can say that it's for an actual reason. But with all of these types of different types of trademarks, to secure registration, you need to apply and meet the legal requirements of the Trademarks Act. The requirements of the Trademarks Act are quite specific and different to business, company, or domain name registration. Even if you're able to register those, so say you applied to ASIC and you got your business name, it doesn't necessarily mean that your trademark can be registered. I'll soon step through a couple of those legal requirements to give you an idea of what to expect, but that is just the essence. So different concepts, business names, domain names, and trademarks. Next slide, please. And while a trademark cannot be required for all businesses, if your branding is an important part of your business, and let's face it, in this day and age, branding is very much an important aspect of trade, you should know about the potential risks you'd be taking if you choose not to register a trademark for your brand. So here we surveyed 91 small Australian businesses and found that 48% had to rebrand as they were unable to secure a trademark. And data from the US shows that rebranding costs for small businesses go upwards to $130,000 to $240,000. A survey of global brands showed that 3 out of 4 trademark infringements led to litigation. And in Australia, the legal fees involved in litigation can be north of $100,000. So it's an expensive endeavor. There are also significant costs to opportunity. So as our study indicated, the businesses who have registered their trademark are 30% more likely to achieve higher turnover growth compared to those without. A trademark secures the value of brand, and without one, it can often limit your ability to expand and to obtain investment. Next slide. If you're successful in getting your trademark registered, it is up to you to enforce it. If IP Australia, facilitates the registration of trademarks rather than enforcement, sometimes this can mean litigation, which can be costly. But we want to share 3 cheap and direct ways you can protect your brand today with a trademark that costs nothing except your time. All right, we've got Google AdWords. So if you have a competitor using your name in their advertising, you can submit a trademark infringement claim with Google. If successful, the ads can be removed and the advertiser penalized. You'll see, for example, on screen over here, that a competitor can still bid on your keywords, but cannot use your name in copy. So an essential reason here for trademark registration. It's also possible to do a Australian domain name removal. So if you find another provider using the exact trademark in their URL or domain, you can seek to have them removed by the AU domain register. Finally, you can also submit notice to the border force if somebody else is infringing on your trademarks or bringing the goods into the country for commercial purposes. Quite exciting, very border force on Channel 7 kind of vibes. It doesn't happen often that I come across in my experience, but it is a really powerful tool to stop those serious infringement cases. So these are just some of the benefits of registering your small business's trademark. Next slide, please. Right, let's now to get into how the process of obtaining a trademark registration works. When applying for a trademark, it goes through an examination process where a trademark examiner assesses the trademark in accordance with the requirements of the trademark legislation. There are options to do a preliminary check via our TM checker service, which I'll go through a little bit later. But next slide, please. When you apply for a trademark, you need to nominate what goods and services you like protection for. There is a list of about 70,000 goods and services you can choose from, and people often struggle, understandably, with deciding what to choose. Basically, you want to select the things that you're offering to the market in connection with the trademark you've chosen. Most likely, this will be people paying you for something, or think about what they are paying you for. What is the actual service or good that is being provided? A key component of trademark rights is use of the trademark in respect of the relevant goods and services. So selecting only those goods or services that you're intending to use or are using your trademark in relation to is really critical. So for example, if you're not using or intending to use your trademark in respect of the goods that you have claimed, the trademark may potentially be open to an application by third parties to remove your trademark from the register for non-use. The classic phrase for the regime in Australia is use it or lose it. Sounds a bit intense, I'll confess. It's not that scary, but use is really critical when it comes to trademarks. Some of the questions you might ask when considering which goods and services you might need to claim are you producing a tangible item that they can pick up and take away, or are you facilitating that retail of those goods? Are you providing expertise in a service-based offering? What is your area of trade? What industry are you operating in? Those are all relevant when considering your goods and services. And it can help you narrow down the claims that you might select when applying for an application. When you are using a classification selection tool, try different keywords that may represent your goods and services to understand what might be out there. For example, if you're operating in a software space, you can try different words like software, app, platform, developer, software as a service, computer, those sorts of things. All of these will come up with different results that you can look through. In fact, you can do so right now even by Googling trademarks classification search, which is a standalone platform that contains that 70,000 long list of goods and services. And that could be used as a tool to preemptively think about what you want to do. The list of these goods and services is broken down into 45 classes. This is an international system to help with searching and applying for trademarks. So it's an administrative tool. The cost of the application is based on how many different classes your goods and services fall into. So you can choose 100 things in the same class and the price won't change. But if you select one thing in another class, you will have to pay that additional fee. Sometimes this will be unavoidable, depending on your industry, but such is the requirement of the trademarks regime. Next slide, please. All right, now getting to the meat and potatoes of the essential requirements of a registrable trademark. So first, your trademark needs to be different to other traders that already exist on the trademarks register and are providing goods and services that are similar to yours. If you're selling goods and services similar to someone else, it's best to have something totally different and unique, as we see here on the left. On the right, you can see that you can sometimes use the same word as another company, so long as you're providing different goods and services, so that no consumers would be confused about whether you're the same company or not. And consumer confusion is the concept that underpins this particular concept of similar trademarks. When going through the application process, an examiner will run a comprehensive search on the register to find such similar marks. A registered trademark only protects goods and services the owner has chosen, or that is something that is similar to them. So this is how different companies can have names for different things, such as here we have Antler, the luggage company, and Antler, the venture firm, capital firm. Next slide, please. The next legal requirement that concerns the fact that your trademark has to be able to show that your chosen goods and services are coming from your business. It can't be plain words or basic images that everyone in your industry should be able to use. Here we go. Here's an example here. Think about the word apple. People have a genuine need to use this word to describe the fruit, naturally. So you couldn't get a trademark registration for the word apple if that's what you were selling. However, when we're looking at it in respect of computers, it is no different. It isn't a term that other traders need to use in relation to computers. So Apple have been successful in registering it as a trademark. There's, of course, understandably a natural desire to let your customers know what you're offering as part of the service or goods that you're offering. So for example, if I want to make a brand of spaghetti, and I go with a very good spaghetti brand as my trademark, because it might do a good job of telling my customers what I offer, great spaghetti, but it would do a really poor job of making me stand out from other traders. One only has to look at the top 30 most valuable brands in the world, to see that it is the distinctive trademarks that tend to rule the school, as it were. That is not to say that less distinctive trademarks are not registrable or enforceable. It is possible, and there are provisions in the legislation for that, but those come with particular challenges that you may have to think about. Next slide, please. Right, you may be wondering, when is the right time to apply for a trademark? There isn't a one-size-fits-all answer here, but generally speaking, sooner the better. As soon as you have your name locked in, applying for registration of your trademark is a small investment for your peace of mind. It means you can be more confident spending money on advertising, packaging, other branded products, knowing that you're on track to have your rights secured. As you become more successful, it's likely that people will try to copy similar success for themselves. So having that registration in hand makes it easier to stop others from using your trademark without your permission. That being said, there's a lot to do and learn when you're setting up your business. So getting a trademark understandably might not be at the top of your list. You might prefer to take your idea out into the market and test out the name to see how it performs first before investing in a trademark. The risk here, of course, is that the aforementioned copycat might get in first, and you'd have to spend your time and money chasing after them. So there's pros and cons, to each side, and you have to consider the business risks for yourself. But no matter what, when you decide to apply, it's a good idea to check your name as soon as possible if you have some ideas in mind for its registrability, to make sure you're not infringing someone else's trademark, and to make sure that it's functioning as that badge of trade origin. Next question. Oh my God. I need a coffee, am I right? Public service. Embarrassing. And here we go. To help small businesses with checking availability of their trademark, we have created the TM Checker tool that I mentioned. It is an AI-assisted trademark insight platform. And as part of this initial availability check, TM Checker will guide you through basic requirements of registrable trademarks and will make a preliminary assessment of sorts so you can get some more help in making a business decision. You can go to tmchecker.ipaustralia.gov.au or scan the QR code over here on the screen, and you can use this tool for free to check your brand name or logo for that initial availability check. And later on, if you're happy with the results or if you want to inquire further, you can transform that initial inquiry into a formal application process to get that ball rolling. Next slide, please. Right, so you've spoken about business names and trademarks, but let's complete our piece of the tapestry and let's get to domain names. Next slide, please. A domain name gives online businesses a unique electronic address. That is the essence of it. You can arrange to buy a domain name yourself or through an internet service provider, an ISP. And to buy .com.au or .net.au, you must be a commercial entity and have an Australian company number or Australian business number. Our gracious host, auDA, develops and administers the rules for the .au country code domain. You can check the availability of your domain name registration on their website. And while domain name is itself an internet address in essence, as we know, often the address can be reflective of the brand that you might be trading under. So similar to business names where there's that a bit of a gray area where a domain name and a business name can be a trademark, but a trademark isn't necessarily the same as those two other concepts. But if somebody is using your name in their domain name, they can potentially be infringing on your registered trademark. So you can request for that domain name to be removed. So that's one of the ways that domain names come into play when it comes to intellectual property. Next slide. All right, final stretch. To summarize, business names, domain names, and registered trademarks, they're all important aspects of your branding strategy that have different purposes and benefits. Business names are legal requirements for businesses to trade with a name other than their own, but a business registration itself does not offer exclusive rights. So really important thing to remember. A trademark, on the other hand, if registered, gives you those exclusive rights to use the trademark and your brand. And finally, domain name is an internet address. However, the address can contain a trademark and potentially be used as part of a use case, or if somebody's infringing your brand name in a domain name, that may be a cause for pulling the domain name down. Hope that was all clear. Now I have time for some questions, which I was more than happy to answer, and hope I wasn't too frantic in me jabbering away.
All right. Thank you, Sergey, for that. And I thought it was very timely that the slide with the similar goods and services were all chocolate brands. So very timely on Valentine's Day. So very well done for that.
Love was in the air, truly.
All around. We do have a few minutes for some questions, so please do pop them into the chat if you would like to ask Sergey while we have his while we can benefit from his wisdom. But we do have a couple for you, Sergey, and I'll start off with this one. As an NGO, is it okay for me to register a .au domain name, even though an unrelated corporation uses the same .com.au domain name? And I'll give you a shot at that, but I can certainly possibly answer some of that as well. But I wanted to give you the first serve.
I will give you the trademark spin because I am not familiar with the requirements of auDA and domain names. From a trademark perspective, if the brand and the domain name are similar to some extent, such that a consumer would be confused, that potentially may be a problem in the trademark legal space. Of course, for domain names, my understanding is that a top-level domain name, such as like .org.au, is a different makes the domain name different. So there is room for to have both two separate web addresses. Is that correct, Andrew?
Yeah, so to that answer that question, so thank you for that. But yes, if you, as an NGO, if you're an organisation, you could register a .org.au. If you could provide evidence that you are a registered association or charity, or even a .asn.au, but there's no reason there couldn't be another company with .com.au or simply .au direct under that namespace as well. There's some good questions coming in. I will throw this one at you, Sergey. This is an easy one. How long does a trademark lodgement take, and how much does it cost?
How long's a piece of string? So we have a number of different filing services. I'll try to keep it brief. So a standard filing service costs $250 per class. When I mentioned we have 45 different classes of goods and services. That $250 via SAN application typically takes 1 or 2 months to get to an examiner to assess. That is one of our services. The other is the aforementioned TM checker. So you go through the TM checker process, and if you're happy with the results, you can then convert it into a pre-assessment. That pre-assessment, you will get a 1-week turnaround from an examiner getting a response on your trademark. And if you're happy with the examiner's assessment, you can pay what's called a Part 2 fee. That Part 2 fee converts your trademark into a fully fledged application. And if there were no issues with your assessment, then you automatically get an accepted trademark within 2 weeks of lodging the request. So those are two services. For Head Start, the price is it's a part two-part system. The first part, the number escapes me, but I believe the first part is $200. So $50 cheaper than a standard application. So here's the reason for that is if you're not necessarily happy with the outcome, and if you want to readjust your strategy, you're kind of saving the $50. But if you're happy with the result, you pay the Part 2 fee, which I believe is $150, so $250 total, and it proceeds to the application. And the extra you're paying for is the expediency of the results. But more information, of course, available on our website if you want to have that down in writing. So hopefully that answers your question.
Okay, thank you. And we might just add the IP Australia website into the chat. And I did also add the IP checker page to the chat as well, which is well worth checking out.
Thanks, Andrew.
Just a question about getting a copy of the Zoom. Yes, we will. These are being recorded and it'll be available on our website shortly. So you can certainly access that. Another good question, what if you register a trademark and want to add services to it, presumably after the fact?
Yes, so great question. One of the things I personally deal with is such requests. So requests to amend a trademark after it's been registered. So the Act is quite strict in once a trademark has been published. So once it has been published, there are very limited amendments that can be made to the trademark. So if you want to add services that expand your original scope, the legislation simply doesn't allow it. The reason for that is that the register is used as a record for other traders like yourself to make business decisions over. So for example, if you want to enter a market into shoes and you see a brand, Nike, but then Nike later on has an additional claim for computers, and then you just started trading for computers as well. So out of nowhere, even though you've done your due diligence, Nike is coming after you. So that's the thought process behind that. So it's really important to consider what you're intending to use your trademark in relation to in that first instance, because later on, there's very limited opportunity to add additional goods and services.
Okay. And so just to paraphrase, you're saying you cannot extend a trademark into other areas under any circumstances. You need to relodge the trademark?
You can refile claiming these additional goods and services. You can have as many trademarks as you'd like, but it cannot be within that same trademark registration. It would have to be a brand new application.
Okay. All right. Thank you, and thank you for that. I'm going to throw this question at you. How has the rise of online businesses impacted trademark registration and enforcement?
Well, it certainly made it more lively. Um, it's actually, in many ways, it's made um, prosecution of trademarks much easier, because in the past, if you were to compile evidence to um, support your claims or defend yourself, uh, you would have to produce old-timey pamphlets and surveys. But now with online services such as they are, you can submit evidence of your Instagram followers, your engagement, how many website hits you have, how many sales you've made using your online retail platform. So the internet is extremely useful in building that case for how reputable your trademark is. Um, it also has made it easy in many ways to infringe, but also to protect against infringement. So it's the snowball effect that's really evident at IP Australia and in the courts. There's new things happening all the time. But again, going back to that Google example I mentioned earlier, it's really important to sort of cast a fishing net and have a wide net, looking out for potential infringers and things of that nature, just so looking out into the internet void and make sure that your brand is not being copycatted.
Okay. Interesting. Thank you. And there's just a couple of other things. I'll give you first crack at this one also, Sergey. If there is a dispute relating to a domain name, what is the pathway to resolution?
I feel like I'm an exam, Andrew. Unfortunately, I cannot speak on the dispute of specifically domain names. Disputes and trademarks can be based on domain names. In fact, courts very recently have considered use of a domain name to be infringing. And it is possible to do that in the trademark space, either via prosecution in the courts or via an opposition process with IP Australia. So if a trademark is accepted and it's a domain name that you're not particularly happy with, you can object to it via the opposition process. But for the technical requirements of dispute for auDA, unfortunately, I cannot speak on that.
Understandable. And I can just speak to that. I mean, the first step I would do is always contact auDA to ask if there's an avenue possibility of having the domain reviewed. There is a process which we do have, which is our .au dispute resolution process, which I can put in the chat now. But I would stress the first step is always to contact auDA as well, and we can certainly hopefully answer some initial questions on those issues. I'm going to throw this one with you also. What are some of the common mistakes that you see from businesses make when it comes to trademark registration?
Well, speaking of business names, it is extremely common, and understandably so, because the system is so arcane to anybody who's not in it. But when applying for a trademark, it is common for applicants to use their business name as the ownership name. Now, that is not allowable because a business name, the ones we discussed, the ones you register with ASIC and with the Australian government, it's not a legal entity. To own a trademark, you have to be an individual or a company. A business name does not have a legal personality, so oftentimes we receive applications and it would be in the name of Bob's Burgers, the business name. So it's not fatal by any means. An examiner would query the ownership, and you can resolve it by an amendment later on. But it's just like a bump in the road that is really, really common, and you can just avoid the headache by just doing it right in the first place. Another common thing is, again, when I was talking about the distinctiveness of the trademark and similarity of the early trademarks, really, really important to consider whether it's valuable to do your preliminary searches, use TM Checker. Perhaps you can contact a trademark professional if you really want that kind of legal advice assurance. if there are other similar trademarks out in the register, or if your trademark is distinctive enough to be outright registerable. In saying that, the other really common thing is that people come in with an attitude that if a trademark has been objected to, it means it's outright rejected. That is absolutely not the case. For the vast majority of objections that we raise, there are opportunities to resolve them, for example, via evidence of use or filing various documents or amendments. So it's never an outright rejection, just a proposal to reject the trademark, which we can work on in a dialogue. So it is a dialogue that you enter into with an examiner. So if you choose to apply for a trademark, don't be afraid if you do get that adverse report from the examiner.
But the key point is to do your homework first. Here's what you're suggesting.
Certainly.
Raise that. Okay. Thank you for that. I'm always interested to know, Sergey, what's been your most memorable trademark application that's popped across your desk that you've seen in your years of experience?
Well, you always remember your first. And a good example of the objections that we take. So my very first trademark that I've examined way back in the day, when I was a wee young lad, it was Australian breath hold games. In respect of sporting services. So breath hold is a type of diving competition where you hold your breath for as long as possible. And in considering this application, we raised a ground for rejection because the trademark wasn't distinctive enough, because it was describing the services that are being provided. I cannot speak on how the situation went after I raised the report, but when we raised that objection, it was fairly severe because of how descriptive it is. So again, remember that very horrible, very good spaghetti example. Try to make your trademark really distinctive when applying because it'll make your brand that much more powerful.
Okay, thank you. All right, and I'll just note a comment from Mark in the chat. Thank you, Mark, very much noted. But thank you for those questions. We have reached the end of our session today. I should just stress, I do apologise for the slight disruption at the start of the presentation, but I'm glad we were able to get there in the end. But a huge thank you to you, Sergey, for your answering those questions and for your sharing your knowledge and wisdom today with us. Just before we do wrap up, I want to mention 2 webinars that auDA is hosting over the coming weeks. There they are. Next Tuesday, 20th of February, in collaboration with the Cybersecurity Cooperative Research Centre, auDA is hosting a panel discussion which will explore auDA's cybersecurity strategy 2023 to 30 with a high-powered panelists collection of panelists speaking on that. And also this month on the 28th of February, still on the topic of cybersecurity, we are hosting a cybersecurity workshop for small business with Cinch Security. That's the 28th of February. You can, of course, register for those webinars via the events page on our website. And please also keep an eye out on the .au weekly member newsletter for updates on those and upcoming events as well. As always, if you're not already a .au member, I strongly encourage you to join. .au membership is complimentary and connects you to a range of resources and events. Again, you can join via the QR code on your screen or via the auDA website, auda.org.au/join. If anyone has any questions about .au membership, suggestions for future events, please reach out to us at membership@auda.org.au. But on that note, thank you for joining us today. Wishing you an enjoyable rest of the Wednesday and enjoyable Valentine's Day. And we look forward to seeing you at a future member event. Thank you very much.
Thank you, everyone.